Hi, everybody. Mitch Tannebaum here. Thanks for joining me today. This is the CMMC update for this month, and it's a wild ride. So you might want to put your seatbelt on. Probably going to want to get a notepad out because you're probably going to want to take notes. And for sure, if you have questions, please reach out to us. So I've been saying all along, no surprise here, there's two parts to the CMMC rule. One part is Title 32. That's the mechanics. What does it take to get certified? What are the certification levels? All those kind of things. That was published in December, and that's well on its path to getting to the point where we think the final rule is going to be published maybe this month, and then there's 60 days, maybe September, 60 days, and then it becomes final. So likely before this Congress is out. The other part of it is Title 48. And if you keep seeing me look to the sides, because I'm looking at my notes, because this sucker is complicated. The Title 48 part of the rule is the part that talks about what's the contracting language. How do you get CMMC into a contract? It's much more compact. You may remember that the Title 32 part of the rule was about 230 pages. The Title 48 part of the rule is only 57 pages. Of the 57 pages, 44 of those pages are explanation. The purpose of that is to set the groundwork so when people complain about why'd you do this, then they're going to say, we already told you that. Next comment, please. So that's going to really hopefully speed up this whole comment period. There's only 13 pages to the rule itself, so that's not very big. All right. And this rule, this Title 48 rule, is called the clause rule. I don't think that's the official name. I think that's the name that some people in the industry are giving it because that's where the clauses like the 7021, 7012, those clauses are in that rule. Part of in the setup in this 44 pages, and again, a way to knock down some of the complaints, DoD says that they have no viable alternative to accomplish the objective other than this, meaning, my opinion, my editorializing here, back in 2017, they said 80171 is mandatory, and everybody laughed at them. They ignored them. So they're saying, okay, you want to ignore us. That's your prerogative, but we're going to make this very painful. If you ignore us, you won't get any contracts. Okay. There's going to be a new DFARS, that's the Defense Federal Acquisition Regulation Supplement, which is given a placeholder number of 252.204-7 YYY, meaning, gee, when we publish it, it'll have a number. And that's going to be for RFPs, not for contracts. I'll talk about contracts in a minute. For RFPs, this is a warning that says, if you get awarded this RFP or the contract comes out of this RFP, then you will need to have CMMC at this level, either attestation or certification or whatever you're going to need. So it could be level 1, it could be level 2, self-attested, it could be whatever. But they're telling you with this 7YYY clause in an RFP, here's what to expect. And oh yeah, by the way, you can bid on the RFP if you don't have that, but you will not get awarded the contract. So that's that. The basic structure, as I said, is 44 pages of explanation of why they're not going to listen to you whining and 13 pages of the actual text. All right. So what does it say here? So a lot of the 13 pages are instructions to the contracting officers. It does revise the 7021 DFARS, which already exists, which is the CMMC DFARS. It creates, as I said, this new DFARS, the YYY DFARS, and it tells the KOs, contracting officers, when they need to make use of these various different contract clauses. So that's page 2. We're moving fast. Okay. The clause that's actually going to show up in contracts is 4 paragraphs long, 779 words, 4 definitions, and 11 requirements. It's pretty damn simple. The provision that's going to show up in the RFP that makes you aware that you're going to have to worry about this clause in the contract, the 7YYY DFARS, is only 375 words and 3 paragraphs. So neither of these clauses, either what's going to be in the RFP or what's going to be in the contract, is very long. The YYY clause, it says, notice, here are the CMMC requirements that are going to be mandatory if we accept your bid and we award you the contract. So that's pretty straightforward. DoD does not have enough acronyms, so they created another one. In SPURS, there's going to be this thing called the DoD UID. We don't know how that's going to be pronounced, but it's a DoD unique identifier. And when you post a score in SPURS, after this thing goes into effect, you will get a UID. If you have a third-party certifier, because that's the requirement you have, then the third-party certifier will put that UID, will post your score in SPURS, which will generate a UID for you. You must tell the government's contracting officer, if they ask, what UIDs are applicable to this particular contract. That way they can look in SPURS and see what's going on. That is, you could have more than one DoD UID, because you need a UID that covers each and every system that is involved in executing the contract. So, for example, like some of our customers, you have an Amazon cloud and you have a Microsoft cloud. Potentially, you're going to assess those separately, which is fine. And each one of those, if you assess them separately, is going to have their own UID. So that's just kind of the way that works. You could have 1, 2, half a dozen UIDs. They all have to be current. They all have to be managed. But you need to tell the government and probably your prime, what UIDs are applicable here. That way, if something happens, they can go pull that UID. They can pull the certification that came with it and decide who to hang by the local yard arm. The YYY clause is just going to have very simple language. It says, the CMMC assessment required for this contract is blank prior to award for each system that will handle FCI or CUI. Talk about there's a lot of wiggle room here. So, and I have a difference of opinion that from some people. Contractor will not be eligible for award if they don't have a current certification. That's where, in a situation where you need a third-party certification or assessment, that's when you're doing it yourself, and a current attestation. That's where the CEO gets to sign on the dotted line and put his neck in the noose. So basically that's all that's going to be in the 7 YYY clause. So, pretty simple. The 7021 clause has, which is the CMMC requirements, has 6 requirements. First one has 2 parts. Number 1, you have a current CMMC certification or self-assessment at level whatever. That must flow down to subs, and they must also do the same thing. Next is that you must maintain that CMMC level for the contract duration for all systems used on the contract. Number 3 is you're only allowed to process or store CUI on systems that meet that requirement, that is certification or assessment. Number 4, you must notify the KO within 72 hours. It's not a very long time, of any material changes to the CMMC status. Now, what constitutes a change? They haven't said, but I am sure they'll be happy to hang you up if their opinion of what to change and your opinion of what to change are kind of different. So probably be cautious there. Next, you have changes to CMMC status on an annual or other changes. At other times, you have that attestation that you have to tell them about. And number 6, that subs need to go off and maintain that same level of discipline. That's going to be a challenge, right? Because you're going to have a requirement that your subs have their act together, and that might not be the case. As I said, you could have multiple DoD UIDs for different systems. That's perfectly okay. And there's mandatory flow down for any subs that get either FCI, Federal Contract Information, or CUI, Controlled Unclassified Information. Now, the thing about FCI, first of all, there's no poems allowed. You've got like 17 controls, and that's it. and no POAMs. So, but there's a mandatory flow down. Likely, other than a sub that's providing commercial parts for you, if Home Depot is your sub and you're buying some nuts and bolts from them, well, okay, that's commercial, and they don't have any federal contract information. All they know is they're sending you some nuts and bolts. You're cool there. But if the sub has federal contract information, then all of a sudden they have to comply with FCI. And that has to be prior to the sub being awarded the contract and for the duration of the contract, just like for the prime. Now, here's where the wiggle room is and the difference of opinion. So it is up to the program manager to decide what level to put in the -7021 clause. Some people might say, well, gee, they want to cover their butt and they're going to put level 17 in there. But what's going to happen, I predict, is the primes are going to say, oh, you want level 2? That's great. We're just going to double the price of the contract and you can take it or leave it, because you're not going to have any choices of who to give this contract to. So I think they're going to be much more cautious. Some people think they're going to try to cover their butts. We shall see what happens there. But it is totally up to the contract officer and the program manager to decide what is going to be required. And I think that's where you're going to see a lot of wiggle room. Unlike a lot of things, this applies to anything above the micro purchase threshold, which is $10,000. This is not the streamline purchase threshold, which is $250,000. This is the lower estimate. So any contract more than $10,000, which is pretty much anything, it has to comply with these rules. So that's pretty serious. DoD really does not know how many folks this affects. One of the things of having this DoD UID in SPURS is, for the first time ever, it'll give DoD some visibility to how many folks are in the DoD supply chain. But that's going to be years off before they really get any visibility to it. At least at a minimum, if you're really generous, 2 or 3 years, realistically, probably 4 or 5 years. So they don't know. They don't know how many people this is affect. The problem you've got is you don't know when you're going to need to be CUI certified, maybe sooner, maybe later. And you can bid on a contract, but if you wait till you're bidding on a contract to start your CMMC prep, you're screwed. It's just, you're not going to be. Two things. Even if you have a magic wand and you wave it, the folks that do the certifications, assuming you need a certification, they're backlogged 6, 9, 12 months. So they won't even get to you at that point. The reality is it'll probably take you 6, 12, 18 months to get ready. And if you haven't started, I think you got a problem. So there is a phase-in period in this Title 48 clause. It's way too short, but again, there's wiggle room in it. So phase 1 begins on the effective date of the publishing of the 7021 clause, the new 71. The effective date is 60 days after publishing in the Federal Register. So some people are estimating June of next year. That's certainly possible. What happens then is you got CMMC level 1, level 2 self-certification at the discretion of the contracting officers / program manager. It also, same way, affects option year awards, and also at DoD's discretion, level 2 certification. So a lot of wiggle room there. They can say everything requires certification. They can say nothing requires certification. And if we're going back to self-attestation again, this is liar's poker. So, no different than where we are today. Other than likely it'll change. You might get away with, this for some period of time. Phase 2 happens 6 months after phase 1. So if phase 1 happens in June, maybe the end of the year, now we've got level 2 and level 3 certification, but still at DoD discretion. So not clear that is going to really change much of anything. The phase 3 is level 3 certification. We think that's probably the end of 2026. And then the phase 4 is all CMMC levels, and maybe that's Q4 of 2027. So that's kind of the rule there. And I know I went through that pretty fast. And I think that you're going to have questions. You know how to contact us. So please ask the questions. We will try to answer them. No guarantee that we will have all the answers, but we will certainly try. So, as I said, you won't have time to deal with this after the RFP. If you want to do something, get it done now. The simplest way, and this depends on whether this is going to work for your business model, to make this work is to create an enclave. Potentially, an enclave could be one computer. That's perfectly legal. And needless to say, the rules for one computer can be dramatically simplified. Now, the reality is one computer is probably not going to be enough, but, maybe 6 computers, 5, 10 computers, something like that. It becomes a whole lot more manageable at that point if you do that, and we'll see. But I think enclaves are the way to go. The other thing that can work in your favor, and again, depends on whether this works for your business, is you can say, as part of the contract bid, you can say the prime is required. This doesn't work if you're the prime, of course, but assuming you're a sub, as a condition for award, the prime will set up an enclave for us on their infrastructure, and they will be responsible for the compliance of that infrastructure. We have clients who are doing this using virtual desktop infrastructure. That is absolutely the way to go do that. There are some caveats in terms of making that work. There are some vendors out there that claim to host enclaves. Mostly they're going to be, I was going to use a word, I'll be kind, mostly they're going to be ineffective at accomplishing the goals that you have to accomplish. Those are okay if all you're doing is pushing paper. If you're responding to an RFP and the RFP itself contains CUI, which is certainly possible, then you need to have your CUI certification before you can even look at the RFP to decide if you want to bid on it. So very complicated, lots more to come, but at least this will give you kind of a start and try to figure out what's going on, what do I do? And, please, what we do for a living is answer these questions. So, please reach out to us and, we will, you can engage us and you can do this very inexpensively. So just let us know what you want to do. And I think CMMC is beginning to become very, very real. Until next time, thanks for listening. Stay safe, stay secure, and get your CUI hat on.